Are we recording? Yeah.
You're on, yes.
Oh, great. All right. We're going to start our final work session of the day. We'll start with introductions. Ms. Zalatel.
Christopher Constant,
Austin Davidson.
Felix Rivera, John Weddleton,
Forrest Dunbar.
Jessica Willoughby, Assistant Municipal Attorney. Crystal Kennedy.
Lee Peterson, Dean City Council.
Wonderful. Okay, so we are going to talk about 2020-17 ordinance providing for time-limited closure of municipal property for the cleaning of waste and other hazards. Who is here to present on the ordinance?
I'm here to present on the ordinance.
Do you actually have a...
I did, but my computer isn't turning on, so I'm just going to go off my notes. It's a very short presentation, so I apologize.
Okay.
If my computer suddenly turns on, I will, of course,
Mr.
look things
Chair.
up.
If I might briefly interrupt, I just wanted, since
Sure.
this is the first time I've seen you, to say welcome back. It's been a long time, and I'm glad you're here.
Thank you.
Yep.
Thank you. I'm Jessica Willoughby, and I'm Assistant Municipal Attorney in the Municipal Attorney's Office. As Mr. Constant pointed out, I'm actually just returning from maternity leave, and while I've talked to Ms. Wynn Pearson about this ordinance, the AO and AM is not all my own language, so some of the language I might use today might be a little bit different. But I was asked to provide some information about the AO AM today, and I'm going to start with some background. So, prohibited campsite cleanup in the MOA has largely been premised on the fact that camping on municipal land is prohibited by our code, both under nuisance and trespass law, and that in enforcing that law, such campsites should be abated. And I've been asked before, abated is a fancy legal term for removed. In practice, however, and as laid out in Anchored Home, the MOA's strategic action plan to solve homelessness, the MOA has largely adopted a multifaceted response to ending homelessness, which many would argue is at odds with criminalizing or otherwise penalizing sleeping outside when there is nowhere else to go. And that aligns with the reality on the ground. While APD is involved with the abatement process in order to remove encampments, APD does not often cite people for sleeping outside. And the abatement process seems to be just as much about public health and safety as it is about nuisance or trespass. So what does this ordinance do? This ordinance makes explicit that the MOA may close an area to public use for the purpose of cleaning apart from any prohibited use, apart from nuisance, apart from trespass. The MOA already has this right to close land, but in adding this language, we hope that there is increased transparency to what cleanup goals are. So how does this relate to Martin v. Boise? Martin v. City of Boise, as you may recall, is the Ninth Circuit decision that held that if a person experiencing homelessness has no other option than sleeping outdoors, a city cannot cite them for violating an anti-camping ordinance. It's a decision we've talked a lot about. The spirit of the decision, its shift away from criminalization as a tool to dealing with homelessness, falls within a housing-first strategy, and in that way it also aligns with what we've been doing. Monitoring shelter availability, conducting outreach, instituting a coordinated entry system, and closing to clean is also appropriate under Boise. Ninth Circuit courts have already heard challenges to other jurisdictions' close to clean approach, and when upholding the close to clean approach, courts have focused on different things cities have done, including suspending enforcement of anti-camping ordinances, notice procedures that protect due process, other procedures to protect property rights, all things we're working very hard to establish here. So what does this ordinance not change? MOA's commitment to protecting constitutional rights, improving community health and safety, cleanups rid of parks of tons of trash each year. We provide notice, outreach, restore people's properties when necessary, and our concerted efforts to get people off the street and into housing. So with that, I take any questions.
Anyone? Questions here? Oh, Mr. Weldon, sorry, I didn't see your hand.
So, this is just clarifying, or this gives us more powers?
So we could say, this area is closed for cleanup for a year. Can't come back, stay away. That would, it gives us something we don't have so much now.
You know, I think through the chair, the right to close land to public use is a right that we already have. And I think Mr. Duran from Parks and Rec can talk to that. I think what this does is make it more explicit and also help reflect the reality of what our abatement process is about. It's not just about nuisance and trespass. It's also about public safety.
Yeah, sorry.
And health.
So I'm just trying to think, so we did something recently, if the fire department calls something dangerous to burn, they can close it. And we said, well, everybody really? What if there's a trail through it? You can close Chester Creek Trail? And we said, well, except for trails, we carved that out. So there was this kind of thing. So here I go, oh, where are my carve-outs? You know, we're really just kicking homeless people out like normal, but we're clarifying that we can kick them out forever. But what if there's a trail there? You're going to kick me out? Then it's not a good law. I mean, these same arguments come up, right?
If I might, I don't think that's what it does at all. I think that it's a
That was
limited
the question.
I know it's a limited closure. And you can't say for a year. It has to be enough discrete time that you could actually enforce it. And the purpose is to clarify. We would use similar posting methodologies. This area is closed, so it wouldn't probably be the whole trail and everything. What we had contemplated in the conversation of crafting this is say north of Chester Creek, between Valley of the Moon Park and C Street, for the next 5 days, it's closed for the purposes of cleanup and abatement. With the proper notice that's required, you'll see that that's maintained here. So if a 10-day notice is required, to get the 10-day notice, and then for the next 5 days, this place will be cleared for cleanup. And so it's very much not looking at creating a large area that we say is closed for a year. It's tailored to specific uses. Now, what Ms. Willoughby suggested is we already have this power, but this is just a clarification of the purpose and intent of this power.
Thank you. Yeah, Mr.
I was
Sherwood.
just going to respond to your example, Assemblymember Weddleton, about closing it for a year. If we had a valid reason for that, like if there was a terrible chemical spill and we really needed a year to go in there and clean it up, but if it's some kind of a pretextual thing, then we'd be in trouble.
And specifically, we'd be in trouble because we'd be sued by who would have standing to sue us.
Well, I think, we remember the so-called ACLU case, but they never represent themselves.
Yeah.
They found campers that had standing and then represented them, and I think that's how that type of thing would work if there was a lawsuit.
Okay, so we've got people in queue. Pete, then Meg, then John, then Chris.
Well, thank you, Mr. Chairman. I was just going to ask Josh, I saw him here, if the cleanup crews, have they been having trouble or that they've been getting harassed by some of the campers when they're cleaning up in the parks? Is that possibly why this is coming forward, or?
That, I would not say that's why this, through the chair, I would not say that's why this is coming forward, but that does exist, but CAP provides the appropriate assistance when we need it as it relates to that topic.
That's what I thought. Okay. All right, thank you.
Thank you, Mr. Peterson. Ms. Zalatel.
Thank you. Just a little bit of a refinement on Chris's point. If an area is noticed for abatement and then it's closed for cleanup for a period of time, one thing that also does is it lets us get a little bit beyond that, like maybe that zone abatement, to do a little bit more cleaning or clean more thoroughly in that area, and have the time to clean it and to possibly stop that next pop-up, like we just went right outside the area type situation that we've all heard about, the whack-a-mole type situation, until the area is clean and deemed ready to be reopened. It also isn't restricted, I think, and I think this is important, to the greenbelt or places people camp. In theory, it could be used in other places. Before Ms. Pearson left, I had an opportunity to talk with her about the idea of Carluck Street downtown off of 3rd Avenue, because we could need to clean that from time to time. Like you might want to power wash it and pick up trash and keep it clean for a period of time. That would be appropriate and allowable under this, as long as we had the reason, we posted it in advance, and then we did what we said we were going to do.
But to be clear, it's already the case that we could close Carlick and clean it and post things.
But under the ordinance, it's clear that it fits in with the strategies we're using that are so in this particular area around homelessness, I think, and I think that's important. Like, I think it's important to be clear that we are talking about specifically to do these types of things when we do this. Litter, garbage, rubbish, junk. Like, we're being clear, if we close under this, this is what we're doing. I hope that makes sense. So that there's a purpose here. And I think that gets to Mr. Sherwood's point about pretext. Like, if we're citing, like, we're closing under this, there's a reason there. And I think that's important. I think that's transparency and clarity.
Okay, thank you, Ms. Alto. Mr. Weddleton.
You know, we have a number of people, Waterways Council, but actually beyond them, who are working to do a test of our waterways, find out how much E. coli is there, and doing all kinds of scientific stuff to say it's these campers here, so to show a health crisis caused by the campers. So presumably, if they could do that and say, we had a health crisis because of these campers, here we kind of wave the flag, say, yeah, we'll close the park because of that. Could we be then compelled to say, hey, we're closing down every green belt because these creeks have super high dangerous levels of E. coli, and that could be indeterminate until the E. coli level gets better. I don't know. Actually, I'm looking at it.
Through the chair, sure, if there's an outbreak of a communicable disease in our waterways, I'm sure either the Department of Public Health at the MOA level, at the state level, would want to take some precautionary steps to ensure public safety. I don't necessarily think that this ordinance would change our response to a public health crisis. I think this ordinance changes perhaps the communication, as Ms. Zelatel said, in terms of the transparency of what our abatement efforts are about.
Mr. Gates, you were in the queue. Mr. Gates.
Thanks, Mr. Chair. I want to suggest a small change to ordinance. When I read this, the final lines of the new language on page 278, it goes to require the removal of a campsite vehicle or the property prior to closing and clearing. But to me, it makes sense. If you're going to be cleaning the area, you don't need to require the removal of these other things before you clean it at the same time. So I would suggest adding has been noticed for removal in compliance with municipal code instead of removed in compliance with municipal code, just so that you've got an illegally required notice for a prohibited campsite or abandoned vehicle, junk vehicle, or other property. Get an illegal notice for removal, and then after that legal notice period is complete, you can close it and clear those things as well as all the rubbish and junk at the same time in one action.
So
I also would mention I had some suggested changes to this I sent to Ms. Pearson, but she didn't see them before we submitted it. So I'm not sure those with some members that are interested in seeing some of the other suggestions I have to the language. Some minor changes.
I'd love to see them.
Good.
Sure.
Mr. Weddleton and Mr. Constant.
I think we're
Okay, Mr. Constant.
Yeah, so one thing you'll notice about the language that's before you is it doesn't mention the word homelessness anywhere. And Ms. Pearson was extraordinarily studious about crafting this language in that way. One of the intents behind implementing this system is that in the light of the Martin case and the fact that what has been shown to be policies that are targeting homeless individuals are tending to find higher and higher levels of scrutiny and falling under the courts. And so even our abatement policy, which I support, can be argued targets homeless people as a target. And so what this code does instead is it takes an area of the municipality and closes it off to everybody, not just an individual who has no home, but everyone who is enjoined from being on that property. And so in that way, we move to a policy that is generally applicable to every citizen in the municipality instead of a policy that targets individuals without homes. And so it was her belief, I think, that she communicated to me that this would move us closer to or stay closer in compliance with the Martin decision so that our practices can continue in the kind of tempo that we've been engaged in, but can do so under less threat of being found unconstitutional. And so the policy intent, I believe, here is to generalize a practice, from one that may be argued to target homeless people to target more broadly anyone in an area that's been deemed to be unsafe. Now, I fully support that argument. That's why my name is on the top of it. I do, though, have my concerns, because the reality of municipal enforcement is that we only have limited resources. And what ends up happening if the policy only is used to target areas where there are homeless encampments, and as soon as the camps are gone, we de facto turn our head and people are back on the land using the park, then we have effectively done the same thing that we were trying to move away from, which was an argument for taking more time once this is introduced to talk through with the departments and to talk through with various parties to make sure that what we're doing doesn't turn into a de facto tool of what we are trying to move away from du jour. And so the argument is, at its core, strip out the targeting of homeless people, make it generally applicable to all of us, but we have to think that through a little bit, I believe.
So I'm going to ask a question for Josh, I think, and for Chris and for the municipal attorneys. So what Chris just said, and I think what Megan said too, sort of implies that this is a new policy tool that is not targeted at people experiencing homelessness. But I think your position is, and maybe I'm confused, is it this is a new tool for us to use, or is it just we are stating a tool that we already have? And if we're stating a tool that we already have, and I think that is the case, then I'm kind of puzzled as to why we're doing this at all. I mean, we have the right to close land. We have the right to clean it out. So I still don't quite understand why we're doing this particular ordinance. I'm looking at you, Josh.
Yeah, okay.
Is this giving you is this giving the municipality new substantive power, or is it just stating a power we already have?
My understanding is it is stating the power we already have, and it's helping address potential future legal barriers as it relates to that power.
What are the barriers? So one, somebody really smart told us we needed this, which was Miss Whit Pearson. So there's a really important point. Because she did survey the landscape of, the legal decisions, and this clean and clear idea is an important one, and one that is permissible and is a tool we already have, and this makes it explicit for this particular purpose. So I am on board with that. With Dean's change, which I really liked. So I think it's good that we are being transparent and clear about this clean and clear procedure for these purposes, because I don't think people are aware of it, and I'm not sure it's quite as explicit anywhere else in code. That's the thing. Like, I think it's implicit in code in other places, but not explicit.
Mr. Whittleton?
Actually, 2 points. One is pretty explicit here. Just before this is stated, it says we can do anything a private person could. It's pretty explicit. But I have a question. So we have in the code we did where if the fire department thinks they could burn wildfire danger area, that they can close it. Did we have in there that they had to, this last sentence there, that they could close it and no one could be there? Did we have in there that it had to be properly noticed if there was stuff there? Do you know that?
I don't, through the chair, I wasn't here when that ordinance passed, and I'm not sure. I don't know if my colleagues do. My sense is that it did not.
I sponsored that, so no, it didn't have a notice provision. It was because it's an extreme fire danger, it's a safety automatic, it's like quits.
And it's based on weather variables that are measured by a third party and demonstrated to the fire chief, who makes a determination based on cause, and it's all clear.
And there was a shortened notice provision, yes, John, as to if you found a campsite, I think it was 24 or 48 hours. I have to refresh my memory, but yes, there was a notice provision for those folks, unless there was imminent danger, and that just was already a power implicit in code anyway to remove people. We just made it explicit in terms of that.
So we could take all their stuff and say, sorry about that because of that?
No, we would still have to store it and do all the other things that apply.
Unless it was going to burn down, people were going to die.
Still close to it.
I'm sorry, Mr. Peterson.
Thank you, Mr. Chairman. So, and this just sort of follows up that conversation. So this is sort of an extension of the policy we passed last summer that allows us to clear parks out because of fire danger. This just provides additional detail that we're just trying to make this more visible, this policy more visible to the public. So you have any answers to any of
Someone
those?
who's a sponsor?
Yeah, no, this really is the next evolution of the abatement policies, not the fire policies. That just was an example brought up by Mr. Weddleton because it has some cognates within the code. So no, this really does aim to move us into a place that is more legally justifiable should the question be called. And we've done well so far to stay out of the fire of potential actions in front of the Ninth Circuit, but only because we've been working hard to make sure we have a place for people to go if we're going to move them. We honor the 10-day notice. And so this generalizes our policy away from being directed at a set of individuals and instead makes it clear that it's for all residents of the municipality. And so it helps us to implement a fair policy if, of course, on the back end, we do it fairly and equitably and not just in a de facto way. And so that is the conversation that we're working toward, is making our code less subject to hazard in the courts because it is targeting a subset of vulnerable individuals. This should be for everybody. It should be for you and me and the person without a house, not just the person without a house. And so I think that's where we're aiming with this policy. We're going to shut it for them. We're shutting it for you too.
And so we'll be reducing the chances that we might get sued. Is that one of the reasons for doing this? Thank you.
So I have a drafting question. I still remain a little skeptical that we need this for the reasons we talked about earlier about whether or not this actually accomplishes anything. But if we're going to put it in code, it might as well be drafted in a way that is clear. So, Mr. Gates, your suggestion was that we change the word removed to noticed for removal. Is that right? Use of property has been noticed for removal in compliance.
Exactly. Notice for removal.
So is there any worry that if you say that, then, so if you read the whole sentence, in the event that such property contains a prohibited closure may not occur until it's noticed for removal, but it's not just that it's noticed, right? You have to go through the whole notice period, right, before you could do the closure. Is that right?
Let me back up a little. I put up my changes. It's not, I didn't mean to replace removed. Instead, just add words after removed or noticed for removal. And then the last phrase that modifies this is in compliance with municipal code.
Yeah.
So whatever municipal code applies to the notice required to remove a junk or abandoned vehicle, you need to go through that process.
Okay.
And that period of notice, like 7 days or a few, I'm not sure. I didn't pick it up. There's different period for
The other suggestion I had with the drafters was to take the words to on line 1 of page 2. It says normally open to the public to access by the public, and it's just sort of a little bit of a strange phrase. Line 1 on page 2. I might take out to the public and put it on the previous page where it says right to close to the public or to public access. Right, to public access, because you sort of repeat yourself. You say, which is normally open to the public to access by the public, is sort of redundant. So I might take one of those two phrases and put it in front of closure on line 1, or line 41, sorry, on page 1.
So,
is that clear what I'm saying?
Sure.
Okay.
I personally, I know that there's some pressure to get this passed, and there's some countervailing pressure to have a little more robust conversation. And so I would like to suggest that I would like us to have the public hearing as properly noticed on the agenda, and then delay or move the public hearing, continue the public hearing to another date after, so that we can have a little more thoughtful conversation with some other folks.
If you want to, I mean, we have 35 minutes today if we want to use the whole time, and I think with those kind of amendments after public hearing, I think it might pass. I don't know.
I know, I just have some real fear that we have to talk about implementation how it's gonna be implemented, not just we put it on the books and that we have this power, because my fear is that we create a system that we use, but we only use it for the people we say we're creating the system to protect.
I mean, you're one of the
I know. and
co-sponsors, so I'm happy to
I am
delay your.
supportive of it, but I want us to walk through that kind of thing, and I don't think we're gonna do that in this. I think it's more of a conversation with some various parties.
Okay. Mr. Weddle?
We have, what I think is a nice thing, a new kind of AIM that says, here's the thing, and here's the stakeholders I've talked to, and councils and so on. I used it once, I think, but it's useful. Do you have something like that?
No.
Did ACLU see it? Did you shop this to?
My experience with ACLU
Coalition.
is they'll tell you, the devil's in the details. Once it's passed, we'll come and have a conversation. And so
That would be.
But yeah, so we have it. It was introduced pretty abruptly on the passing of our former attorney from our employment to better employment.
She went to a better place.
Yeah, she went to a better place.
I think moving on up.
So it is before us. I know that what the department needs, and I'm hopeful that the department has, is enough whatever tools in their toolkit that they can put together for us, including the 8th floor, a briefing on the plans for the summer, so we can understand where we are in the schedule for ramping up teams for cleanup and abatement. Kind of, because I'm starting to get questions from the public, even at like 10 o'clock at night. Last night I got one, is the meeting preparing for the summer? And so it would be nice to have a little briefing on that, conversation how this fits. No, I know, but here it comes, y'all.
No, there's not going to be a summer this year. We're not going to make it.
So anyhow, that's what I'm hoping. This is part of a broader conversation, not just that we rapidly run through it and get it done.
Okay, so you're one of the administration, who is also a co-sponsor of this. What are your feelings on the timing of passage? Who here is comfortable speaking on behalf of the administration?
I will, through the chair, we'll follow your lead.
Okay. Mrs. Alatelli?
Thank you. We could work on this some more and have our next conversation about this, and maybe a more wholesome conversation about the summer plan at the March 18th Committee on Homelessness meeting. And I know it's not just necessarily tied to that, but the interplay between the two, I think, is going to be, will captivate the public's attention as to how this will work. There's only one other item on the agenda for that meeting, which is the Brother Francis Beads campus discussion. So in some ways, it all kind of ties together, and maybe we'll know a little bit more about the plans also for the monies we've appropriated for overnight shelter for the summer, from May to December. And I think all those things intertwine into a system, so we could really kind of wrestle with this in some context.
Okay. So,
Do we have a meeting on the 17th of March? Or is it on the
No, it's on the 24th.
24th?
okay, so what I'm hearing from the co-sponsors is that we want to open public hearing on this coming Tuesday, and then to continue public hearing to the meeting of March 24th. That's what we want to do? Okay.
It's kind of long, but there's the meeting with the homeless committee. It's fair to have it there, unless there's no opportunity.
And it's also the position of the sponsors. This actually does not change our legal powers at all. So,
I think what it does is puts us in a cleaner line should the question be called in front of the courts. And so it just reorganizes how we talk, how we look and feel. And that is important, because the scrutiny on the question of homelessness in the Ninth Circuit is getting tighter and tighter and tighter, not any way looser like some people would argue. And so we just have to walk that line.
Ms. Quinn Davidson.
Thank you. If this isn't about homelessness, do you really want to take it up with the homelessness committee?
That is the one question that's reasonable to contemplate. I just don't know if public safety, homelessness, or what's the proper venue to have a conversation
We
about.
could do another work session on it. I mean, if y'all want. Mr. Weddleton.
Parks and Rec Commission, send it to them.
That's actually good. When were their meetings?
But some of these lands probably aren't parks, right? They're just general use lands.
Yeah, through the chair, given the broader scope of the proposed changes, separate work sessions, I yield.
Yeah,
So
I'm fine with
then
that.
we want to push it out to the 25th, or just till the 24th, or just till the 10th?
I'm okay with it. I think we could answer these questions, but I'm okay with the 24th. So what do you think?
I don't care.
Okay. By Tuesday night, please tell me. Or we'll just figure it out on Tuesday night. So
No,
I'll make a
we'll have a
motion to
plan.
continue.
We'll have a plan.
And we'll do a work session in between then and 10. Okay, is there any other closing thoughts on this topic? We have a little bit of time. Is there any audience participation? Yes, Mr. Haber. 3 minutes. Any member of the public?
My name is Eugene Carl Haberman. Just one thing that's most striking in your conversation on this last item is the word homelessness. How many times did you say homelessness in this meeting? And you're doing legislation, and you're trying to say it's not going to be, it's not really what you're doing a more general area in that. But homelessness was mentioned so many times, and then toward the end it says, should we have this discussion in a homelessness meeting? Get real. That's all I have to say, because the truth isn't the matter to what was said here. It is about homelessness, but you're trying to dodge the bullet. And I don't mean it in any violent way, but the legal way to what you're doing. Thank you.
Okay, thank you, Mr. Haberman. Anything else? All right, with that, close this work session.